Hello, future travelers. Welcome back to Legalopolis. First of all, congratulations to all those of you who made it through the lottery process. And if you did not get through, don't lose heart. There's always another opportunity. So, friends, for all H1B aspirants, regardless of where you stand in this process, this video is for you. We are here to address the following topics related to H1B visa in significant depth to ensure that every one of you feels empowered and informed about their H1B journey. We'll cover what is H1B visa, its eligibility criteria, what is H1B cap and exceptions, how does H1B lottery work, what is concurrent H1B, what to do if you got selected in the lottery, and what to do if you were not, and also the entire process of H1B visa and information about H1B dependents. So friends, let's unlock the full potential of H1B visa together. Since we always begin from the basics, what is H1B visa? H1B visa is a non-immigrant visa that is sponsored by employers, allowing foreign workers to work in specialty occupations in the United States for up to 6 years. And therefore, the eligibility criteria to apply for H1B visa are threefold. Number one, it must be employer sponsored, meaning that H1B visa must be applied by the employer on behalf of the individuals they wish to hire. Prospective employees cannot directly approach USCIS to file an H1B application. Number two, the hiring and employment must be for a specialty occupation. Now, specialty occupation means any job that requires both theoretical and practical application of highly specialized knowledge and skills. And therefore, individuals seeking H1B status must possess specialized educational qualifications tailored to the complexity of the occupations they intend to pursue in the United States. As per USCIS website, the H1B specialty occupations include fields such as architecture, engineering, mathematics, physical sciences, social sciences, medicine and health, journalism, education, business specialties, law, theology, arts, etc. Friends, the minimum degree expected to be possessed by the employee who is holding an H-1B visa is a bachelor's degree in the field where the applicant will be employed. However, there are certain roles like research program positions which generally demand a higher level of specialized knowledge or expertise, and therefore they might require a master's degree or a PhD. But friends, there's an interesting exception, as I've mentioned in my previous videos. For fashion models, there's no specific degree requirement. Instead, they must primarily showcase distinguished merit and ability. And we come to point number 3. The third crucial factor that is required for H1B visa is the required remuneration or salary for a job under H1B status. The employer hiring a H1B worker must certify and demonstrate to the United States Department of Labor that they will pay the employee either the prevailing wage or the actual wage, whichever is higher. Now, the prevailing wage reflects the pay for similar roles in the area where you will work, while actual wage is what your employer pays for similar positions at your work location. So, for instance, if engineers in San Francisco typically earn $100,000 annually, but your employer pays its engineers $120,000 yearly, then your actual wage for H-1B visa purposes would be $120,000. Now friends, let's look at the validity of H-1B visa. The H-1B visa is initially valid for 3 years, with the option for holders to extend it, allowing them to stay for a maximum of 6 years in total. You can submit a renewal application to USCIS up to 6 months before your current H-1B visa expires. And while the process resembles the initial H-1B application, you don't need to enter the H-1B lottery again. Now friends, let's look at what is H1B cap. H1B cap denotes the maximum number of H1B visas that can be issued in a federal fiscal year, which runs from October 1st of current year to 30th September of the next year. So, from 1st of October 2024 until 30th of September 2025. Now, as per the present regulations, USCIS allocates a total of 85,000 H-1B visas annually. And out of these, 20,000 are allocated for applicants who possess a master's degree or a higher degree from a US institution. And the remaining 65,000 visas are reserved for regular applicants with a minimum qualification of a bachelor's degree or its equivalent. Out of these 65,000 H-1B visas up for grabs, 6,800 are reserved exclusively for H-1B1 applicants from Chile and Singapore. The limit on H-1B1 for Chile is 1,400 and for Singapore is 5,400. However, friends, there are certain H-1B petitions that are cap exempt, meaning they are not subject to the numerical limitations of the annual H-1B cap set by the government, that is 85,000. These are, number one, certain specific organizations like higher education institutions, non-profit research organizations, non-profit organizations associated with higher education institutions, and government organizations. So what this implies is that individuals seeking employment in these organizations won't count towards the 65,000 or the 85,000 H-1B cap. These organizations can submit H-1B applications to USCIS at any time during the year and are not restricted by the fiscal year or the H-1B cap. However, if someone moves from cap-exempt employer to a non-exempt one, they may then become subject to H-1B cap. The second category are petitions which are filed for H-1B visa extensions. The third category are petitions to modify the terms of employment of current H-1B employees. Number 4 is petition for transfer of H-1B status to a different employer. Number 5, petition by the H-1B visa holder to be employed in another job, which is also known as concurrent H-1B. Now, concurrent H-1B typically refers to a situation where an individual holds more than one H-1B visa simultaneously, allowing them to work for multiple employers at the same time. Each employer must file a separate H-1B petition for the employee to make this happen, and each petition must meet the necessary requirements set by USCIS. If you would like to know more about concurrent H-1B, please do share your interest in the comment section, and I will definitely make a separate video detailing more information about concurrent H-1B visa. Now friends, let's look in detail at the process for H-1B visa. Now friends, it's important to familiarize ourselves with the steps involved in the process for obtaining an H-1B visa, particularly if you are a new applicant. So let's walk through the specific tasks you need to complete as well as certain responsibilities that your employer has to undertake so that you can become a qualified H-1B visa holder. First step, that is for you. Find a company or employer willing to sponsor your H-1B visa application. If you are currently on an F1 visa in the United States, inquire with your employer about sponsorship. If you're already employed, your current employer can sponsor your H-1B visa, or if you can seek sponsorship from a new employer, go for it. Step number 2. This is for your employer. The US employer initiates the H-1B registration process. Now, unless sponsored by a non-profit entity or university that we just learned about, all H-1B applicants must go through the H-1B cap quota. USCIS typically opens the H-1B season quota for the next fiscal year in the March of current year. And so, USCIS would open the H-1B season quota for the fiscal year starting 1st of October 2025 and ending on September 30th, 2026 in March 2025. Now, during the H-1B registration period, employers use the online H-1B registration system to input the applicant's details such as legal name, gender, date of birth, country of citizenship, and passport numbers. Employers must register through the USCIS online registration tool within the time frame. Otherwise, they'll have to wait until the following year's March to register. Then comes step number 3. Following this, a lottery is conducted. Now, a lottery is needed because there are only 85,000 H-1B visa slots available for new applicants, while the number of registration exceeds this limit by a significant margin. And hence, lottery ensures a fair and unbiased selection process by USCIS to meet the cap of 85,000 visas. And in order to reach the cap of 85,000 visas, the number of times a lottery is run varies every year. USCIS typically selects more H-1B registrations than the mandated cap to accommodate factors like denials, non-filings, and revocations. For the fiscal year 2025 season, USCIS introduced a new process where the selection was based on a unique beneficiary identifier instead of the H-1B registration itself, and therefore all applicants had to mandatorily provide their passport or travel document number. This unique number from either document was used for lottery selection, and therefore even if an applicant had multiple job offers and submitted multiple registrations, they would be counted only once for the lottery. The passport number serves as the primary selection criteria from now onwards. This process ensures that all applicants have an equal and fair chance of being selected in the lottery. Now friends, let's see how the lottery process works. Step number 1. A lottery is conducted to select H-1B registrations to fill the regular quota of 65,000 visas. Step number 2. Registrations or applicants not selected in the first lottery are entered into a second lottery, which is exclusively for the US Masters quota, which has a cap of 20,000 visas. Step number 3. Applicants selected from both lotteries are notified, allowing them to proceed with submitting their H-1B petitions. And step number 4. Registrations or applicants not selected in the initial lotteries are set aside. They may have another opportunity in future lotteries if there are still visas available after the initial selections. So those of you who were not selected might have a chance if a third lottery is conducted. Then friends, following the lottery processes, individuals are notified through the USCIS accounts via USCIS form I-797C, also known as the Notice of Action, and will ask you to file your H-1B cap petition. Now, in the meantime, employers who want to hire foreign H-1B visa applicants must complete LCA, that is, Labor Condition Application. Now, the Department of Labor collaborates closely with USCIS and the Immigration Department to ensure that the employer has the financial means to hire and sponsor a foreign national for the H-1B visa and can afford to pay the required wages. The employer confirms to LCA that no US worker will be displaced due to hiring of the H-1B employee, and there are no strikes or work stoppages where the H-1B applicant will be employed. Additionally, employers must also verify the educational qualifications and criminal background of the foreign job applicant for admissibility into the United States. Now, these declarations are made under the penalty of perjury and must be submitted to Department of Labor for certification through the Labor Condition Application, that is LCA form. Now friends, perjury means knowingly lying under oath, which is a very serious offense. It happens when someone gives false information where they should be telling the truth, like in a court or in official situations. Now, if someone lies on the Labor Condition Application, that is LCA form, for an H-1B visa, it could be considered perjury and could lead to legal consequences like fines or even imprisonment. Now, friends, generally the Department of Labor reviews the LCAs within 7 or 10 working days to check for completeness and any errors. Employers can track the status of their submitted applications and access certified ones anytime through the flag system. Now, once they have a certified LCA, they can proceed with the visa application process through USCIS and the Department of States. Now, friends, please note that the LCA is linked to H1B job role rather than a particular person. Therefore, employers have the flexibility to submit the H1B LCA either before or after the H1B registration process as per their preference. Typically, employers prefer to do it after the employee is selected in the H1B registration so as to avoid the hassle of withdrawing it later. Then we come to the next step. Once the certification has been granted, the employer submits a non-immigrant worker petition form, that is I-129, along with the certified LCA with USCIS within the time frame which is mentioned in form I-797C. Friends, normally this must be done within 90 days of the selection date, which is typically by 30th of June if the applicant is selected on 1st of April. The employer submits all necessary documents for the applicant's petition at the designated lockbox, which is a change that has taken effect from 1st of April 2024. So basically, from 1st of April 2024, I-129 petitions can no longer be submitted at USCIS service centers. Instead, all paper-based petitions must be filed at USCIS lockbox locations. This change applies to all types of H-1B filings, including CAP, non-CAP, and CAP-exempt cases. A properly filed I-129 petition should be supported with important documents like H classification supplement, necessary filing fees, a copy of any written contract between the employer and the beneficiary under which the beneficiary, that is H-1B applicant, will be employed, evidence showing the proposed employment qualifies as a specialty occupation, and this could be shown by documentation such as employment letter with specific details about the job, like detailed job description, job duties, dates of employment, salary offered, position requirements, and contact information. Then, evidence showing the beneficiary is qualified to perform the specialty occupation. Supporting documents to demonstrate the beneficiary's qualification to perform the occupation can include their academic qualifications, training certificates, membership documents, and also their resume. Now, if applicable in a situation, a copy of any required license or any other official permission which is quintessential for the beneficiary to perform the specialty occupation in the state of intended employment. And of course, a labor condition application that has been validated and certified by the US Department of Labor and signed by the petitioner and attorney or representative if it was applicable in your case. And the last one, evidence the beneficiary has maintained status if the beneficiary is seeking change of status or extension of stay on their H-1B visa. Now friends, it's crucial to familiarize yourself with the required documents beforehand so that you can gather them and support your employer in filing a complete Form I-129 petition by the deadline specified in the selection notice. Missing this deadline or submitting an incomplete petition can lead to denial, rejection without any exceptions. Now, for those of you who weren't selected in the lottery, don't worry. USCIS might conduct additional lottery selections if H-1B visa slots become available. They must utilize the 85,000 cap in the current fiscal year, offering another chance for non-selected candidates to secure an H-1B visa lottery. Now friends, USCIS will process your petition, which includes all the documents submitted by your employer along with Form I-129. USCIS assigns a case number to this petition, allowing you to track its status online. Typically, your employer or their legal representative will have this number and share it with you. You can then visit the USCIS website to track your case's status. And if you have opted for premium processing, you'll receive updates on your case within next 15 days. Now, friends, you can also check the processing time of your I-129 petition at the location where your petition was submitted on this particular website. Now, friends, it's also important to understand that once your petition is approved, your sponsor or employer will be notified and they will receive a copy of the H-1B approval notice. This approval will also be reflected as approved in your online status. Now, in this situation, there are two scenarios. If you're already in the United States and your H-1B petition was filed as a change of status, you can begin working for your employer directly from October 1st without leaving the country. However, if you are outside of the US, you'll need to fill out Form DS-160, pay the non-refundable visa fee, schedule an interview appointment, successfully complete the interview, and then you'll be ready to travel to the United States on your H-1B visa. And remember, you can only enter the United States 10 days before the start of your job. So friends, this is the entire process for getting an H-1B visa. Now let's look at H-1B dependents. H-1 dependents can travel to the United States with the H-1B visa holder. They are eligible to apply for an H-4 visa, and once granted, they can accompany the H-1 visa holder to the United States. However, it's important to note that H-4 spouses do not automatically gain work authorization by being on the dependent H-1B visa. They must submit Form I-765 and obtain an employment authorization document to become eligible for employment in the United States. The visa is valid as long as the H-1B visa holder is on a valid visa. So friends, in conclusion, staying informed and prepared is key to navigating the H-1B visa lottery registration successfully. With competition on the rise, thorough preparation is essential for navigating this process effectively, and I wish you all the very best for the same. If you found this video helpful, please like, share and subscribe to my channel. Thank you for watching and best of luck with your upcoming visa journey. Until next time, safe travels!